An earlier decision out of our Ninth Circuit, Green v. Camreta, involved a situation where law enforcement comes onto campus and doesn't suspect the student of wrongdoing, but thinks the student is a witness. And so what rights does the student have under this situation? So the facts of Green were very disturbing. There were these well-intentioned CPS officers who suspected sexual abuse. So they went to school, the CPS caseworker and the deputy sheriff went to school, removed this elementary school student from class who they suspected of being the victim of child abuse, and interrogated her for 2 hours without parental consent, and then ended up actually removing her from the house, and that was just horrible. So the family sued after the fact, and raised many claims, including that they committed a seizure of their child. The child was not suspected of any wrongdoing. This child was just a witness. And how can you seize the student in this way without parental consent, without a warrant, without any kind of basis? And the Ninth Circuit held that that was just a seizure and it was unreasonable under the circumstances because they didn't get a warrant, there weren't exigent circumstances, there was no parental consent. So I thought this was actually a fabulous opinion. I'm biased because the judge was a former law partner of mine. But a fabulous judge, and the Supreme Court granted certiorari and vacated the decision on the most convoluted procedural issue that has ever been on my head around. But that opinion is no longer good law. So there's actually technically an open question about what you do when law enforcement comes onto campus, and is it reasonable, and when is it reasonable for law enforcement to come onto campus and interrogate a student who's not suspected of any wrongdoing but is a witness. I think Green was actually very clear and applied first principles. It wasn't a novel application. So I think we should get to this same result if another case comes up. But unfortunately, we no longer have that Green decision as precedential. And so that's all I got.
Questions for you. Do you have a few minutes more? Okay. Linda has a few minutes more, and there may be some questions. I have one, but I'll wait and see if anybody else does. We can kick those questions back and forth, and then we have another part of our program. We're going to look at a video that relates to all of this. Question over here.
What was the name of that decision that Sotomayor was handed down on that?
It was JDB versus North Carolina. Sorry? North Carolina? Yeah.
On the last case, which this was vacated, that was by the California Supreme Court?
No, it was by the Ninth Circuit Court of Appeals.
Okay, Ninth Circuit. Was there any discussion in a convoluted decision about a child being pulled out of school and interrogated without any adult at all along with that child? In other words, this is a minor.
Right.
And so whether or not it's a school environment, often, minors have other protections.
Yes.
So I wondered if there was any discussion about that.
That was one of the things that the court in the Green, before it got vacated, said that parental consent, if there had been parental consent, then that would have made it fine. But there was not, the fact that there was not parental consent or a warrant or any of these other things meant it was not okay.
But then the Court of Appeals reversed that, or they just vacated the entire decision. But what did they say in there? Did they even address that issue?
No, it was purely procedural about qualified immunity when you do this. So it was a purely procedural reason for vacating it.
And it went back. Is it going to be retried?
No, because it's all sort of moved now.
There's a question in the front, and when you get the question, could you repeat?
Yes.
What about when it's in circumstances where the child is endangered and the child gets pulled out of class, the parental consent, how would that work there? Because, indeed the child is endangered.
So there's always an exception to the Fourth Amendment for exigent circumstances. So if life or safety are at issue, then yes, then the law enforcement can sort of get around that. Exigent circumstances is an legitimate excuse.
But the child would still need an adult present, right?
No. So if you have parental consent, that would be one way of fixing it. If you have exigent circumstances because you have reason to believe that child will be in danger, right then, and that there's no time to get it out.
I have a question. I had a question of my own. A minor, does a minor have sort of diminished rights with respect to, for example, the right to an attorney? We've had a couple of cases here in Davis where somebody was interrogated by the police without the presence of an attorney. The parents not notified beforehand. And so, at one point, somebody from the police department said to me that a minor doesn't have the same rights.
Minors absolutely have the same rights, so like there are a million like ifs, right? So one, the right to an attorney is going to be triggered if they're in custodial interrogation. If they're not in custodial interrogation, then it's not going to get triggered. So the police may be saying, oh, we were just, we were just having a voluntary interview, they could have gone, so there was no right to an attorney.
At the police station.
Yeah, right. I'm just saying. Or in the school context, one many pieces of the education we would like to fix, but with this whole issue of student resource officers on campus, if they bring a student who is suspected of wrongdoing, I'm not talking about a witness situation, but a student who is suspected of wrongdoing, and they are interviewing the student, interrogating the student has a right to ask for a parent to be present. But no one has to honor that request. So it's kind of pointless to say, well, you have a right to ask. Well, of course you have a right to ask when people always ask. Yeah. But there is not in that situation, there's not necessarily a constitutional or statutory right. It would have to mature into a custodial interrogation before it did.
Are you familiar, this is another question, are you familiar with the recent activity on the Davis campus where students on campus who were organizing protests discovered that they had, I guess I'll say, agents of the Chancellor's office in their midst.
Undercover campus.
Apparently noting who's there. Is that Ann?
Undercover campus police officer, for one thing.
Yeah, and other folks out of the Chancellor's office too.
Right.
Okay, so is that something that you've heard about? I think with respect to high school campuses, I think I read a case where there was an issue about whether students could meet on campus and decide what they wanted to do without a faculty advisor. There was an insistence by the administration that the faculty advisor had to be present. This was contested. But with respect to